Good morning. Please be seated. This is the time set for argument in Aspen Biotech Corp. Versus Jason Wakefield. It's our cause number 1CA-CV20-0384. Counsel, we have read all of the briefs in this matter. We've discussed this case at conference this morning. Please keep that in mind as you present your argument. We are recording these proceedings, so when you step to the podium to begin your presentation, please make sure you identify yourself and the party to whom you represent. And one final thing before we begin. After numerous years of dedicated service, I would like to publicly thank Judge Winthrop for all of his time on the court, and this will be his final oral argument. So with that, counsel, you may begin.
Thank you, Your Honor. Craig Steffen appearing on behalf of Jason Wakefield, the appellant. And as you're no doubt aware, we got a jury verdict in Maricopa County Superior Court for $562,000 for breach of fiduciary duty by Edward Britt, Mr. Wakefield's former lawyer, and also for constructive fraud. Those are two separate causes of action, and the constructive fraud portion of it includes, if you look at the jury instructions, includes a finding that there was a breach of fiduciary duty, that there was misrepresentation that was relied upon by the client, and that the breach of fiduciary duty tended to deceive the client. So there are additional significant findings that the jury had to make with respect to that cause of action. The reason I mention that is because the judge at one point in evaluating attorney's fees said that Mr. Wakefield had prevailed on only one cause of action, and that's simply incorrect. There were two distinct causes of action on which Mr. Wakefield prevailed. The damage award was the same for each, so you only could obtain damages once. I want to go through these several issues here, and several of the issues deal with damages. We believe that the trial court abused its discretion by precluding our damage expert from testifying at trial. Our damage expert, John White, is a CPA and has several other additional designations. The opposing parties stipulated to his qualifications, so there was no issue as to his qualifications. What the judge essentially...
But he didn't do a business evaluation.
He did not do a business evaluation. However, he did an economic damage evaluation. And that's what he was retained to do, to determine the economic damages in this case. Because Mr. Wakefield was deprived of stock in Aspen Biotech Corporation. He's never received any stock, any money,
Counsel,
any of that.
Did you cite to any reported case that has allowed that type of presentation and that you're requesting in this case? That you can simply look at a personal transaction between two people and use that as the evaluation? Is there any other court anywhere that has allowed that type of testimony?
Well, I'm not sure about other courts that have allowed it, but I know that Mr. White testified that an insider transaction in stock is one of the best methods for valuing the stock.
Did you present any evidence that would indicate that anyone else has taken that position? Or is it just Mr. White's opinion?
Well, we didn't present any case law. We presented Mr. White's testimony. We didn't present the other information we presented to the court was that Mr. White prepared his evaluation pursuant to the guidelines of the American Association of, or it's not the American Association, AICPA essentially, Certified Public Accountants, American Institute of Certified Public Accountants. They have guidelines for preparing damage assessments, and they have guidelines for preparing business evaluations. And Mr. White has testified he's done about 200 damage assessments in cases, damage valuations, and he's done about 300 business valuations in cases. So this is not at all outside the mainstream of what is done. Mr. White...
But has he testified about this insider transaction as being reliable in any other case?
I can't answer that question.
Has any other court allowed him to testify to that, to what he wanted to testify?
I don't know the answer to that question. All I know is that this is the first court that has ever disallowed Mr. White to testify as an expert in a case. First time it's ever happened to him. That I know. I don't know whether there are other specific cases where he's had this specific fact pattern. I can't answer that question because I don't know.
Mr. Staffen, is it correct to assume that Mr. White's scope of work was directed by you?
In other words, he was retained by me. He was actually retained by my client.
That was a bad question. In other words, he was told not to perform a evaluation of this business. Is that fair?
He wasn't. He was retained to perform the damage evaluation, and no one ever told him not to perform a business valuation.
There's probably a difference in the cost of the two, isn't there?
I'm sure there is. I'm sure it would be much more expensive to do a business valuation. Plus, it's not what we needed for this case. A business valuation, the value of a business and the value of the stock issued by that business are two different animals. As Mr. White testified at his hearing, the stock normally has a forward-looking component to it. So the value of the stock is often increased over and above what you would see if you did just a business valuation. If the owners of the company, the insiders, believe that business is going to do very well in the future. In this particular case, the business put in its own tissue facility, which significantly decreased its cost of goods sold. It's Applied Biologics that sells tissue for wound healing, essentially. And by putting in their own facility, they substantially decreased costs of goods sold, which increased their net profit. So there were things going on with this business that would lead one to value the stock over and above what maybe the assets themselves are worth. And so Mr. White testified to all of that. That's not at all magic. I mean, if you look at a lot of stocks out there in the world, the market cap for many, many companies far exceeds what you would get if you did an evaluation of what the assets are worth. So in this case, what we wanted was a value for the stock, because that's Mr. Wakefield was supposed to get 1 million shares, a 1/3 interest in in Aspen Biotech rather, and he never got it. And so the damages are based upon a 1/3 interest in that company, and that's why we retained an expert to value the stock as opposed to valuing the company.
And the starting point of the value of that stock was based on the single transaction?
It was a single transaction, but it's a transaction between Mr. Britt and Mr. Carlson, who were both owners of the company. And insiders, they knew more than anybody did about the company and its status.
But isn't the key question there if that is a reliable method to determine the value? And that's why I keep asking the question, whoever has done this besides it being done in this case?
That I can't answer that. I don't know in what cases Mr. White has ever testified with respect to this fact pattern. And I haven't, I'm not aware of cases where this particular fact pattern has arisen. So I can't answer that question. I know what Mr. White testified to, and I know why we did it. So those are the best answers I can give you. But a business valuation is not, in this particular case, the single transaction was a market transaction between insiders. The fact it's a single transaction goes to the weight of the evidence, not to the admissibility of the evidence. So if the other side wants to argue it's only one transaction, or there are other reasons why you shouldn't believe that my client willingly paid $7 million for 1 million shares of stock, then they're entitled to do that. Talk to the jury and argue to the jury and bring out issues and so forth, but Mr. White should not have been precluded.
So go ahead.
No, I was saying, wasn't some of his opinion, though, based on summarizing the company's balance and income statements from 2012 to 2016? Didn't that play into part of his analysis?
Right, Mr. White did. Mr. White came up with an initial analysis of the value, the enterprise value of the company, and a value of 1/3 of the company. Then he did a forensic analysis of the balance sheets, income statements, and other information relating to the company. He spoke with my client about the company. My client began the company and ran it essentially until he was fired in October of 2014. So Mr. White got additional information. He did a forensic analysis to make sure that there was information in those financials that supported the $7 a share price. And he concluded, based on his financial analysis, and one of the aspects of that analysis was what I just mentioned earlier, the fact that they put in their own tissue bank. So there were several things that he looked at to determine forensically that the value was supported and was supported going forward, because he had the 2015 financials, the 2016 financials as well. The 15 financials showed some basically a loss because there was money that went out to put the tissue bank in. In 2016, there was a net profit. The revenue went I think in 2015 around roughly $9 million. 2016 was over $10 million.
But isn't all that to say that they were using some aspects of what you would normally use in a business valuation, but not all of the aspects, because he certainly disclaimed that he was doing a business evaluation. So is the judge out of line in saying you're either doing that fully, or you're not going to hear any evidence of what that value was in the statements that in the other information outside of the single stock transaction that Mr. White used?
I don't think that's at all the case. In other words, I believe that Mr. White, in preparing the damage evaluation based upon the guidance provided by the American Institute of CPAs, was well within his the standard parameters of operational parameters, I guess you would say, and the fact that he added or used some of these elements that would otherwise be in a business valuation, I think adds to the credibility of his analysis. I'd like to move on to, are there any other questions on that issue? Sorry.
No, Counselor, you may proceed as you see fit.
With respect to I want to hit on our last issue here, which was the fact that there was an instruction that valued damages as of January 2014. And as I've indicated in the briefing, the tort law in Arizona is that you're entitled to all damages proximately caused by the tort. And those damages, because our damages here were truncated as of 4.5 or 5 years before trial, we couldn't prove our damages. We couldn't get everything. So basically, the tortfeasor in this scenario, where your damages are truncated and you have to value them prior to trial, the tortfeasor is getting the benefit of the tort. He's getting the upside on what the business and the stock are doing. So I think that was complete error. I've never seen any case law that said that in a breach of fiduciary duty, constructive fraud scenario, you value damages 4 or 5 years ago. The item D, or issue D here, which is that the court erred or abused its discretion in awarding attorney's fees. As you know, the court awarded all but about $220 of our verdict in attorney's fees to the other parties. And I believe, first of all, that Mr. Wakefield, setting aside the Carlson parties, we don't dispute that the Carlson parties, with respect to Wakefield, were the prevailing parties. However, when you look at the plaintiffs, the counterclaimants, and Britt, as opposed to Wakefield, Wakefield clearly won. Wakefield got a verdict on 2 tort actions for $562,000. Plaintiffs got a verdict on 1 tort action for $124,000. Wakefield got 4.5 times what the other side got. So I think, just as a matter of common sense and looking at the case of Trollope versus Kerner, that when you have this scenario of claims and counterclaims with two different sides, essentially, the net judgment rule here.
Is that the only rule that you can apply in a situation like this?
I don't think I'm not sure it's the only rule, but I think that that in this case, as a matter of law, Mr. Wakefield is the prevailing party in that between Wakefield.
I thought our cases specifically say that it's discretionary with the trial court to determine who is the successful party. Do you have any case that says as a matter of law that you have to use one particular rule or other? I thought the case law was pretty clear that it's discretionary with the trial court.
I'm not sure it's fully discretionary, because there are cases that have reversed the exercise of discretion, because the party that was selected as the prevailing party wasn't.
Well, it's different.
Didn't get as much money.
It's different to say somebody's abused their discretion, but because it could have been based on the facts of the case or the test that they were applying. But we're talking in this case, first of all, what test was the trial court applying? And it was more of a totality of the circumstances test, wasn't it? I mean, he looked at the fact that there was two offers that were made prior to the litigation that were substantially more than the verdict rendered in this case, didn't he? I mean, isn't that the basis of why he thought that you were not the prevailing party? I
don't think that was the prevailing party analysis with respect to costs. Costs are mandated to be paid to the prevailing party in litigation.
I'm talking about the fees.
Right, but I think in terms of costs, Mr. Wakefield was clearly the prevailing party, and 12341 mandates that he gets costs in this case. With respect to the fee analysis, I think there are several mistakes in the fee analysis, many of which I've pointed out to you in the briefing. But for example, the judge found that the second sentence of 12341-01A applied to make the other parties the prevailing parties.
I'm not sure that's what he said. He referred to this, he did mention it, but he found that finding based on applying the factors by the Supreme Court, didn't he?
What he says here is, in addition to the 6 factors and associated indemnity, the second portion of ARS 12341-01A leads to the conclusion that plaintiffs' counter-defendants are the prevailing party. I think that's simply erroneous.
Well, hold on. Do you mean a court cannot consider pre-litigation settlement offers in determining who's a successful party? Is that your position?
It's my position. It's our position that
It calls it
associated
yes or no.
indemnity.
Is that your position?
No, it is our position that associated indemnity was decided in 1985, which is 14 years before the statute, the second sentence in Part A of the statute, was enacted. And I think that after that second sentence was enacted by the legislature, that I don't believe, even though there's not been, as I know, any case law directly on this or that it's been looked at again, I don't believe that one can now look back before the litigation and talk about, a year and a half prior to the litigation and talk about potential settlement offers. Because I think that the legislature was focused on settlement offers that are made during the course of a contested contract action. Secondly, these were not even settlement offers. In our issue number 3, we talked about these prior settlement offers in
Counsel, I see your time has expired. Thank you very much.
thank you.
And for appellees?
May it please the court, my name is Tony Vitagliano. I represent Ed and Kaiser Britt. Our brief took the common issues, and so I'll use 10 minutes, leaving 5 apiece for Aspen and Carlson. With that short time, we direct the court to our briefs, and we'll address Wakefield's reply and presentation today. As to issue A, the court held since White did not apply any accepted method of value in Aspen, his opinions on that subject not reliable, not allowed. Nowhere in Wakefield's opening brief, and thus abandoned on appeal, does he raise his Daubert hearing allegation rejected by the trial court that White's expert testimony complied with ACPA's, quote, consulting services guidelines, close quote. He alleges that at the reply, pages 5, 17, 18, and today. Had he raised the AICPA consulting services standards in the opening brief as required on appeal, we would have informed the court as we do now, such as false. In fact, the AICPA standards for consulting services.
Is this all on the record?
In the record.
Okay.
At 534, at note 1, pages 4, 5, specifically state the definition of consulting services excludes, quote, services subject to other AICPA professional standards, which would include valuation services under the AICPA standards for valuation services. This court can take judicial notice of the AICPA standards for valuation services at www.aicpa.org/research/standards.html. Click on Valuation Services Standard. At VS Section 1, Valuation of Businesses and Business Ownership Interest, go to VS Section 9100 at page 43, paragraph 11. Quote, there are 2 common measures of damages, lost profits and loss of value. If a valuation analyst performs an engagement to estimate value to determine the loss of value of a business or intangible asset, this statement applies. Otherwise, the statement does not apply. In order to determine whether the statement applies, a member acting as an expert witness should evaluate whether the particular damages calculation constitutes an engagement to estimate value with respect to the business or business interest, or whether it constitutes a lost profits computation, close quote. Thus, the valuation standards state that we're here, where the measure of damages is based on the value of a business or business interest rather than lost profits. AICPA requires following the valuation services standards and not the consulting services standard. So the analyst must use 3 accepted business valuation methods, which White says he didn't. In fact, the foreword to the valuation standards, section 100, pages 1 and 2, specifically states that AICPA members are required to follow this standard when they perform engagements, estimates values that culminate in the expression, conclusion, or calculated value. At VS section 100 at .08, page 3, it provides This statement is not applicable to engagements that are exclusively for the purpose of determining economic damages, for example, lost profits, unless those determinations include an engagement to estimate value. In fact, Wakefield's counsel told the court at the Daubert hearing, quote, Mr. White, what he did was he said, this is the value of the company, and I'm giving 1/3 of that is X. So he valued the company and then broke out the stock value. Thus, the court's ruling was proper that, as this court questioned, that was not reliable and therefore not allowed. And as far as whether that goes to the weight or admissibility, Wakefield's own cases, Amorgine, as addressed in the brief, 303 F3rd at 268-69, states this is exactly the purpose of Daubert, to keep out things that would not be allowed because they don't follow the same level that you would in the office. I'll go to his next issue that he raised today, and that's issue G. Contrary to Wakefield's argument, Aspen's value at the time of trial, 4+ years after the breach, is irrelevant. There's no evidence in the record regarding that value. In fact, Wakefield acknowledged there was no discovery as to financial statements for 217 through 219, Mill Transcript 14:1-20. The court previously ruled damages under Arizona law for inducing the purchase of property, as here, and in Cole 423 P. 2nd at 10203, and I quote where the court addressed this, is determined by the property's value as of the date of the breach or the fraud, plus any consequential damages, if any, legally and proximately caused by the breach or the fraud, as pled and proved by evidence in the record. Thus, Wakefield's damages at time of trial would equal the value that he was to receive on the date of the breach, plus any consequential damages, if any, he could prove would legally proximately caused by the breach. As of the date of the alleged breach, his second amended complaint alleges the fiduciary duty was breached when he had executed the transaction documents and didn't receive his shares in January 2014. And the court held numerous times the agreement to provide that stock was the basis of his claims. So Wakefield didn't plead or prove any additional consequential damages legally proximately caused by the damage. No personal injury, no damage to property, nothing. Let alone did he show that it was proximately caused by the breach. If Aspen was bankrupt at the time of trial, would Wakefield allege that his damages were zero? Of course not. He'd argue what happened later to reduce Aspen's value was not proximately caused by the alleged breach, and he'd be right. Same here. Wakefield pled and proved no additional consequential damages proximately caused by the damage. In fact, Wakefield's counsel himself acknowledged Wakefield's contract and fraud damage are the same. Quote, the same thing, close quote. Quote, it's not like a negligence claim where you've got an injury and you can add beyond the economic loss. We're not asking for anything but the economic loss. Different causes of action to get to the same point, close quote. Mill Transcript 13:3-16.
Counsel, because you only have 3 minutes from what you
that's
said,
why.
I do have a question I'd like
Yes,
to ask
please.
you. And it's a big picture question.
Yeah.
Your client was found to have breached a fiduciary duty, in this case, as a lawyer. And yet he was determined to be the successful party against a $500,000 judgment. As a big picture question, doesn't that just smack you as odd?
Well, Your Honor, no, it doesn't, for a number of reasons. One, we don't believe our client was guilty of that, but of course, when you decide...
Well, the jury said otherwise, so let's take it from
Okay, we'll
there.
get past that one. So the judge is in the best position to decide, based on all the factors, who is the prevailing parties. He's given that right. And as you said, as you pointed out, and as the court makes clear, the effects to try and settle it are important in deciding who prevails. And they did try and settle it. They made real efforts to settle it. And as we say in the brief, it's clear that, it's clear that pre-litigation efforts to settle a thing is definitely included because it says avoid or settle. I mean, the law says it. The cases say it. So it does not, again, the law requires you to prove that something a alleged tortfeasor did was the proximate cause of some damages. If you can't prove any of those things, Now the judge looks at, okay,
But he did in this case, $500,000 worth of damages.
well, if you look at it, he claims he wanted 15 million, you know, and so did he win? I mean, our brief talks about the other standard. As this court said earlier, the net judgment rule does not apply, and I cite that in our brief, and there's a case that said it. The net judgment rule does not apply when you're dealing with more than two claims. So when you're dealing with multiple, excuse me for a second. When you're dealing with multiple claims between multiple parties. And so the cases say then you don't use the net judgment rules. The court looked at everything. The court determines, and the court is in the best position, as the cases say, trial court is in the best position to judge the issues, the parties, who did what, as to who was prevailing. So do I find it bothersome? No, I don't, Your Honor. You know, as you said, I can't address what I do find bothersome as far as, you know, this sophisticated business person with everything in there saying, look, I'm not your lawyer, still claiming, hey, wait a minute, I thought you were my lawyer. You know, so the jury, I think they decided, you know.
Well, let's not get into that because
All right.
the verdict speaks for itself.
Right.
And the verdict determined that your client was guilty, and I'll use that term,
Right.
for towards $500,000 worth in damages, and we've now determined that he's the successful party.
No, he's not. It's appropriate to group all the defendants in this action. Don't forget, there's multiple parties here, and if you look at everything done and you look at the factors that the court used to decide who was a prevailing party, they support this group, i.e. the appellees, i.e. the counter defendants and the plaintiffs, prevailed as a group over Mr. Wakefield. And specifically, as you said, Mr. Britt, being the chief officer of the defendant, he's as much tied into the other verdicts as everything else. If there's any more questions, I'd love to address it, but I do have to give my time over to co-counsels. Is there anything else I can?
No, thank you, counsel.
Thank you, Your Honor.
Good morning, Your Honors. I will limit my time to 4 minutes. My name is James Sparks. I represent the appellees Applied Biologics and Aspen Biotech and Martin Castleberry in this case. The claims that were brought by my clients were against Mr. Wakefield, and they were due to his actions prior to his termination from the company and more substantially after the company. In short, the allegations were that he entered into a plan to take Applied Biologics' supplier of their product as well as the distributor of their product. It was a squeeze from both ends to try and steal the company's business. There was substantial evidence to justify those claims. The Raji instruction regarding wrongful interference with business relations was submitted straight from the Rajis. It was the only instruction in there, and it was given to the jury as it's written. The opening brief talks at length about societal interest and competition. The Raji instructions don't require that instruction. No such instruction was requested to be given to the jury. The instructions do in the comments reference the restatement 767 and 768 to determine what constitutes a violation of the claim and also what constitutes a wrongful interference. The opening brief again goes on at length and talks about the freedom of competition and societal interest, but that's a misstatement of what the Raji requires. The restatement requires the restatement, and the interest in competition does not apply when there's an existing contract, especially a contract such as this one in this case, where the agreements with the sub-distributors were not terminable at will. They were ongoing business relationships that required notice and things like that before they could be terminated. Mr. Wakefield had no right. The restatement doesn't give him a right, nor does the Raji instruction give him a right to induce a breach of those contracts, which is what he did. There was substantial evidence at trial. Again, the opening brief and the reply brief talk about the inconsistency in the jury verdicts regarding the claims. The claims between breach of fiduciary duty and wrongful interference, they have different elements, most notably of which is that the breach of fiduciary duty claim was given to the jury as it relates to actions taken during his employment. The jury may have determined that he didn't commit any wrongful actions while he was employed. The jury could have determined that he breached the duty of confidentiality after he was terminated and that was wrongful. The claims are inconsistent, and frankly, they prevailed on that claim. They can't use the fact that the jury maybe could have or maybe should have found breach of fiduciary duty to say, well, the other claim gets thrown out. The question before the court is whether there was substantial evidence or enough evidence from which a jury could find a violation of the wrongful interference with contract claim. There were multiple witnesses. The owner of Mac Medical, Shannon McPherson, albeit his testimony was inconsistent, but he did provide sufficient evidence at trial to support the claim. His testimony, which was given in his deposition and then used against him at trial, was also corroborated by the witness Amber Crowder. It was consistent with Mr. McPherson's deposition testimony. Mr. Wakefield's position on this issue is that he never actually worked for this competing business that was set up called Regen Biosolutions. That's what he said. He said he was just a consultant for them. That's what his witnesses said.
Counsel, was the inconsistent verdict issue raised before the jury was dismissed?
Absolutely not, Your Honor. It was not. And it was required by Rule 49 to have been raised. It could have been a simple issue where it was sent back to the jury if it truly was inconsistent. Our position is that it wasn't, but I don't know that they've been damaged by it because they haven't shown that the result would have been different or even better for them if it had gone back. Finally, Your Honor, that being their position that Mr. Wakefield was a consultant, one of the pieces of evidence that came out was an email that was taken from a computer that Mr. Wakefield used. And it was an email in which one of the agents of Regen Biosolutions, in emailing their tax accountant, referred to Mr. Wakefield as a blind partner in Spectrum, or through a blind partner through Spectrum. When you have an email like that that's completely inconsistent with the testimony of the witnesses, I believe it was persuasive, and I believe there was substantial evidence to support the jury's verdict. I will not say anything further unless you have any questions for me.
No, thank you.
Good morning. May it please the court. My name is Michael Denius. I represent the appellees John Nikolai Carlson and Viking Resources. The claims against John Nikolai Carlson and Viking were three, asserted by Wakefield as counterclaims. Count 1, breach of contract. Count 3, breach of covenant of good faith and fair dealing based upon the same contract. And count 6, fraud. Counts 1 and 3 were expressly based upon the terms and alleged breaches of a document called the Reorganization and Buyback Agreement, which was the initial document that was signed by all three of the individuals involved, Carlson, Britt, and Wakefield. Count 6, the fraud claim, which was added later, essentially, and I'm going to parrot the words of Wakefield's own counsel, arose out of an alleged lack of, quote, original intention to honor the terms of the Reorganization and Buyback Agreement as of the time it was entered. All three of those counts, 1, 3, and 6, Carlson prevailed and Viking prevailed. Viking also asserted a separate cross-claim back against Wakefield for breach of contract on a distinct, separate contractual monetary obligation on which Viking was completely successful. With respect to Carlson and Viking, separate from what you've heard about Britt, Aspen Biotech, and the rest, Wakefield does not appeal the jury verdict finding in favor of Carlson on the fraud claim. He does not appeal the jury verdict finding in favor of Viking on a breach of contract claim. He does not appeal, as it appears, the award of attorney fees to Viking. He appeals two things with respect to these two entities, or rather Carlson and Viking. Is number one, that there should not have been an award of fees to Carlson, and that summary judgment should not have been entered on counts 1 and 3, which included Carlson and Viking, as well as various of the other counter defendants. Perhaps most fatal to Wakefield's claim on the fee award to Carlson is a failure to address apportionment. Wakefield will concede that counts 1 and 3, both based expressly on the terms of the Reorganization and Buyback Agreement, a written agreement, these were fee eligible, as were noted by Judge Whitten in his ruling below. Wakefield argues simply that count 6, the fraud claim, was not fee eligible, and he takes essentially an all or nothing approach, saying therefore that fees should not have been awarded to Carlson. Again, without addressing the apportionment of the various claims, those three claims that were defended by Carlson and Viking in the proceedings. Your Honors, I have no further initial comments with respect to Carlson and Viking. I would invite any questions you would have, because I believe the matters that are being appealed against Carlson and Viking are exceedingly narrow. And I don't believe there's a basis for undoing any of the rulings entered with respect to Carlson or Viking in this matter.
No, thank you, counsel.
Thank you. I'll cede the remainder of my time to Mr. Vitaliano.
All right.
Thank you.
Thank you, Your Honor. If you have no questions for me, I'm fine to sit down. I don't think counsel on the other side has raised anything additionally that's not addressed in our brief. The idea about a sole matter, I mean, we addressed that in the breach. I mean, it's the same thing, and it didn't really come into play because the court says those weren't attorney fee eligible anyways. So I don't know if there's anything the court would like me to address. Otherwise, I'm fine.
No, thank you, counsel.
Thank you,
The
Your
matters
Honor.
deemed submitted will issue a decision in due course. Court's adjourned.